to another edition of the Lawyer's Loft. I am attorney Moshe Moore, and I'm here with attorney Jerome Carter and attorney Freddie D. Stokes. We're talking here today on the Lawyer's Loft about a family law topic. We're talking about a father's path to custody. Often I'll have dads come into my office for a consultation, and they'll say, Ms. Moore, I want to see my kids. I'm just going to put myself on child support so I can see my kids. Should I do that? And many times people are looking for a yes or no answer, but I can't give a yes or no answer without first assessing the facts of the case and understanding what it is exactly the father is looking for. So if we can just break this down a bit. In Alabama, a child support award automatically also gives an award of custody, right? So if you are the dad and you decide to put yourself on child support, the mother with that child support award then has custody, and now you have visitation. So if there is going to be something that comes after that, if you want custody after the fact, then the standard is much higher as compared to if you ask for custody from the beginning. So when you go for child support, you're just automatically giving custody away without allowing the court to really hear you in court, hear what you can offer the child, hear what your perspective is on the case. So when we leave from that to, okay, well, you know what? I just want custody. A lot of people don't know that from the outset, both parents have equal standing. Okay? So we get the dad adjudicated, we get him recognized as a legal father. Now you're both on the same playing fields. Many people think that because the baby is of the mother, and usually the mother has the baby, especially really young babies, that the mom automatically has custody. That's not true. Both moms and dads have an equal fighting chance for custody at the beginning.
Look, I've seen this fight before, and I've always been encouraged when I've seen a young man come into the office to talk about establishing child support with his child.
Right.
But you are exactly right. There's got to be a deeper look at it and a deeper analysis to what his real rights are, because things change, situations change, and a lot of young men are being looked at as not participating in their child's life to a certain degree, and the grandparents are involved in the child's life more than the natural father.
Right, it happens a lot.
Well, then, one of the things that we were talking about earlier is then what happens if the natural mother who has custody of the child pass away?
Right.
Then what happens?
Complicates things.
It complicates things substantially.
Right.
So you want to talk a little bit about that?
Sure. So what we were discussing earlier, and this is a conversation that we had off camera, is just a very interesting area of law, I think. Let me set this up for you. So there is a custody order where mom has custody, dad has visitation rights. We've got that all situated. But then mom passes away. I would think, and I think a lot of people would think, that custody automatically goes to dad. He's the dad. He's the parent. He already had visitation rights. That's his child. Custody automatically goes to dad, right? But what if, when mom dies, there is a grandparent, the mother of that mom, that says, that was my daughter. I know what my daughter would have wanted. I want custody because he only had visitation anyway. I want custody of that child. So now it is grandma against dad that is parent and had visitation rights. Does dad need to do anything? Does dad need to file anything? He's the parent. You would think that that is an automatic right because he's the parent. He already had visitation, but it's not the case. Dad would also have to file a petition for custody.
Yeah. See, I think what the dad has in that circumstance is a priority.
Right.
Absolutely.
There's a priority of the natural parent that is going to trump or beat anybody else that's making a challenge. So then the court will look at the issue of whether or not there would be a dependency, whether this person is fit or not.
Right.
But that's it. Like you mentioned before, that's a fairly high standard for the person that's petitioning. In your example, that grandmother coming in, it doesn't matter. It just doesn't matter how many years she spent with the grandmother,
Right.
the living environment.
Right.
If that father is fit, then that father's going to prevail.
And I don't care if that dad has never exercised visitation rights, if the kid was living in Mobile and the dad was living in Japan. The fact that dad shows up and say, hey, I am able and willing to take care of this child, the courts will not consider anything other than that. And the Alabama Supreme Court and the United States Supreme Court has ruled that grandparents don't have rights that supersede parents' rights in the state of Alabama, unfortunately.
So true.
Right,
true.
and grandparents often will use that, especially if it's the relatives of the mom that has passed away. I've been taking care of the child. I was there when the mom was sick. I know this child. That does not matter when you're looking at this grandparent who is functionally a third party against a parent, unless there are allegations of abuse or neglect or dependency or lack of fitness, then dad has the priority right. I just think it's interesting that it's not just assumed. Dad has to file something.
Right.
So there have been some situations lately where moms have passed away, young moms. And I think that this is vital for dads to know that you need to be proactive about filing for custody. It's not just something that's automatic. And even though there may not be a person fighting you for custody right now, there are things that you may need to anticipate protecting. Maybe there's a death benefit for the child. Maybe somebody may come up later and try to fight for custody and you don't have a custody order.
Well, little things like you're trying to get your child on your insurance.
Right.
And your employer won't look at presumptions. They want to see some order that says that now the insurance company has to, the child has to be on your plan or something like that. There are many different instances, but I think you're exactly right. Father, to protect his overall interest, should file something in the court so that there's something that so if they move to California, there's an order that's protecting the father against anybody else that would come in to try to claim some kind of interest.
Right, and to revisit my initial question, when dads come in and say, I'm going to put myself on child support because I want to see my child, should they do that if what they really want is custody? No, because a child support award is a custody award. And after custody has been established in Alabama, to modify that, the standard is so high. The standard that you have to meet is that a change of custody would materially promote the interest of the child. Not that it's in the best interest, that you can give a better life or live in a better school district, but that living with you would materially is hard. It takes a lot to prove that. So that's really hard. So you don't want to establish this uphill battle, almost, I won't say impossible, but really difficult battle for yourself later on if you know from the outset that you want custody. Fight for it now. In worst case scenario, you get visitation if that is how the case shakes out. But fight for it now. And then at least if you wanted visitation, maybe we have something to negotiate with. We have something to work with. But don't do yourself the disservice if you want that time with your children by just giving that custody award away, because that's what happens.
Absolutely.
If you're going to fight now.
Right.
Is the lesson to be learned.
Exactly.
Because the standard changes so dramatically that it's almost it's very difficult to overcome.
Yes.
So that makes perfect sense to me.
And being careful when you are in the initial stages. For example, let's say the child's mom passed, and you say, okay, at this stage, I really don't care. I am going to allow the child to go and stay with grandma. We're in dependency court. And you realize 2 years down the road, hey, I now want custody of my child. The standard in which you get that child back has now totally changed, right? And I think Moshe Moore was talking about that. And I think, we have to make sure that we understand those very, very different standards.
Right, because now it goes from grandma has spent a lot of time with this child. The child is used to grandma. Now it goes to dad abandoned the child. So that lends itself more to unfitness or dependency. So you need to be mindful of that. And before we wrap this up, just a word of advice. If you know that you are anticipating fighting for custody, realize that your life is going to become an open book. That means that the other side may ask for drug screens. The other side may ask for home visits. Everything will be analyzed and assessed if we're in litigation, to make sure that each side has a strong fight. And attorneys at this office will make sure that your rights are protected, and the attorneys on the other side, they're going to advocate for their client as well. So make sure that everything is in order before we fight, so that we have something really great to sink our teeth into, to make sure that we can come to a good outcome for you.
So father's path to custody, the first step is to call Miss Moore.
Call Miss
That's
Moore.
the first step.
And we'll take it. We'll take it from there. Thank you for tuning in with us on this topic, Father's Path to Custody. Really interesting area in family law. You're here with us at the Lawyers Loft. I'm attorney Moshe Moore.
I'm attorney Jerome Carter.
Freddie D. Stokes.
And we'll see you next time. Thanks.